Good afternoon, everybody. My name's Bill Woodward. I'm a senior fellow at Santa Clara University, and that adjective is particularly striking given the age of the panel here. We have three panelists. Nico Cornell from the University of Pennsylvania Wharton School in the Legal Studies and Ethics Department. He's a 2010 graduate from Harvard with a and he's getting a PhD from Harvard as well. Monika Woodard, right next to me, is a 2015 graduate-to-be from St. Thomas University. Her presentation is on an article that won the St. Thomas Law Review Scribes Award this year, and it'll be good to hear from that. And then Dustin Zacks, 2007 graduate from the University of Michigan. Dustin is a practitioner, and he has a list of publications that would make many of us envious. Our focus is third parties, and we've known for centuries, really, that contracts can affect third parties. Privity of contract made the job of dealing with third parties quite easy. Initially, no one other than the parties that made or had made the promise to were able to enforce a contract. Along came Lawrence versus Fox, which opened what some might even call a Pandora's box by recognizing the rights of some third parties to enforce the contracts that other people had made. And the basic idea there was if the parties to the contract intended that the third party be able to enforce it or get a benefit from it, they would be able to enforce it. And two of our panelists, Nico and Monika, are focused on this end of the third party problem, which is to say their comments are coming out of third-party beneficiary law, which is a major topic in contracts that none of us teaches. The quantum leap, there was a quantum leap in concept came when we also recognized the economic value of being able to trade in contracts. And that really has made third-party beneficiary law kind of the tip of the third-party iceberg because assignment and delegation, all you have to do is think derivatives. And the part of our economy that is driven by that third-party set of ideas is just enormous. In that situation, it's a little bit different because only one party to the contract confers the rights on the third party to enforce the contract. That is the assignor. And that has, of course, anybody who's been paying attention for the past 5 years knows that this has caused enormous problems, particularly in the consumer areas and particularly in the area of mortgages and other kinds of debt. The question typically is what is necessary in order to transfer rights to a mortgage or another kind of contract, and what does the assignee get when that happens, and to what extent does a consumer acquire defenses when that process is somehow non-standard or different from what is perfectly called for. Dustin Zacks has focused on this in his practice, representing consumers on the receiving end of mortgage foreclosures and other kinds of debt collection. We have an interesting assortment, apart from the similarity they have in time of graduation. Our panelists are quite different in one respect. Nico is quite theoretical. Monika is talking about material that comes out of case law, and Dustin is going to be talking about a material that comes out of practice. And so with that, I'm going to start off with Nico. You can begin. Before I stop, I think we're going to pause after each presentation to see if there are comments or questions from the audience, depending on how the time's running. So we'll just see how that works.
So I am a philosopher by training. It's always nice to say quite theoretical, but hopefully this will have some bearing on contract doctrine that you can explain to me. So I'm basically just kind of puzzled by something that I see in the contract law, and hopefully someone can give me a good answer. So the puzzle arises when one party makes a contract with another party under which a third party is an intended beneficiary. And then second, the same party attempts to make a second contract with the third party beneficiary for the same performance. So Y promises Z to do action A, and X is an intended third party beneficiary, and then Y promises X to do A. So this might sound like a really specific set of circumstances, but I think it actually raises some kind of general interesting questions about consideration, rights, duties, and third parties in general. Before getting to this puzzle, let me just sort of describe a few examples to get you into it. I described it in terms of with variables, but American jurisprudence gives a simplified kind of stylized example. Where Brown is under a contract with Smith to perform an act for Jones, Brown's subsequent contract with Jones to perform the very same act has been upheld as based upon sufficient consideration, notwithstanding that Brown is already contractually obligated to perform the same act. So that's one statement by a commentary. And some courts do find sufficient consideration here. So an example is Johnson versus Secor Marine. So what happened here is there's two oil companies, Chevron and Matrix, used a company called PMI to get contractors to provide labor in the Gulf of Mexico. Then the oil companies then contracted with Secor Marine to provide transportation for the PMI laborers to the offshore rigs where they'd be working. But Secor informed the PMI people that they would not transport the employees until they signed a hold harmless agreement, according to which PMI would name Secor as an additional insured and whatnot. So PMI eventually agreed to this. Some PMI employees were injured, and then the dispute arose whether this hold harmless agreement rested on valid consideration. And the Fifth Circuit said that it did. And in support of this conclusion, the court cited various authorities for the idea that third parties gain additional rights when a new contract is formed. So they explained the performance is bargained for, it's beneficial to the promisor, and the promisee is forborne to seek rescission or discharge from the third person to whom the duty was owed. So despite the fact that Secor was contractually obligated with the oil companies to transport PMI employees, its promise to do the same thing could count as consideration for PMI's agreement to waive liability. So that's the Fifth Circuit's view. Now, contrast that with this Youngstown welding case out of the Ninth Circuit. So in that case, ASC constructors asked a company called ProPipe to furnish aluminum bronze pipe, and then ProPipe asked Youngstown to manufacture the pipe. Youngstown requested that ProPipe obtain progress payments from ASC by joint check, and once the details were worked out, there are these two agreements signed between ASC and ProPipe, and then between ProPipe and Youngstown. So ASC made 5 progress payments to ProPipe and Youngstown jointly, and the checks contained endorsement language stating that the endorsement by Youngstown acknowledged receipt of payment and released any lien, stop notice, or bond that Youngstown might have. Then ProPipe went bankrupt. Youngstown brought suit against ASC, seeking payment for the materials that it had provided. So the court now is called upon to decide, is Youngstown's acceptance of the endorsement language, does it bar recovery? And Youngstown argued that its agreement was without consideration because ASC was already obligated to make these payments. And the Ninth Circuit agreed. It said there was a lack of consideration. So the court recognized that a promise to a third party for the same performance may constitute consideration. But because because Youngstown was an intended beneficiary of the joint check agreement, there already was a direct duty, they said. So that is because Youngstown was considered the intended beneficiary of the original agreement, ASC already owed Youngstown the duty, and so Youngstown's acceptance was without consideration, basically. So the parallels between these cases are pretty clear, right? right, the contract was made between two parties in which one party was obligated to provide some service to a third party, and then the third party was asked to sign to waive rights in order to receive this, which they were already supposed to get per the original contract. And yet the courts come out in two different ways. So what's the right answer? That's the puzzle, and I'm not really sure. I think it's puzzling if you look at it either way. So if you think there is consideration, I think you're committed to for what I'm saying mutually inconsistent propositions. So these are on the handout there. So one is just a statement: a promise from Y to X to do A will constitute consideration even though X is a third-party beneficiary of a promise in a legally valid contract that Y has made to Z to do A. So this is just a statement that you're going to take that side of the dilemma. Then the second thing is the thought that the second proposition is that X has a claim right, or a right, which I'm going to call a claim right, and we'll get to that in a second, that Y do A means that Y owes X a duty to A. So this is just the Hofeldian kind of analysis of claim rights in terms of duties. Then third, this is the kind of classic understanding of third-party law that Bill was already mentioning. An intended third-party beneficiary of a promise by Y to do A in a legally valid contract then has a right or a claim right that Y do A. And then fourth, if Y owes X a duty to do A, then a promise from Y to X to do A will not constitute consideration. So this is the pre-existing duty rule. And if you look at these, I mean, I think these are four inconsistent things. You can't hold them all. They're just logically inconsistent unless you find a way out. So I kind of on the sheet there catalog a bunch of ways out, and I'm not going to go through them all. But I want to sort of suggest that they're all a little bit unappealing. And so the obvious answer would be, well, let's reject one. Let's go with the other option in this sort of dilemma. And I think that's also unappealing. So the reason why I think it's unappealing is you have to understand that it goes back to some old questions about the nature of consideration. So for many years, there was a dispute about whether subsequent promise made to a third party constituted consideration. So leave out the third party being a beneficiary, just whether a promise made to a third party was consideration at all. And this was a big debate that involved all the big contract scholars: Langdell, Anson, Williston, Ames, Corbin, like all these big people weighed in on it. And that was at the turn of the 20th century. But since then, there's just become a pretty clear consensus that it does. And so that by the time the first restatement came out, they said consideration is not insufficient because of the fact the party giving the consideration is then bound by a contractual or quasi-contractual duty to a third person to inform the act or forbearance or promised as consideration. So, and if you look at decisions that deal with this now, like going forward through the 20th century, they're all sort of in agreement that a promise to do what one already owes to a third party in general will constitute consideration. And what I want to suggest is that the reasons for this new rule, the consensus rule now, also apply in the kind of more puzzling case that involves this extra bit where there's a third-party beneficiary. So the central reason for the shift to this new understanding is an understanding of rights and duties that's relational rather than just monadic. So whereas the earlier rule was based on the idea that the party in question was under a duty to perform the promised act, the new rule is based on the idea that the party in question is not under a duty to the other party, so in this relational sense. In other words, once one shifts from focusing on merely whether the party in question was under duty and focuses instead on whether the party is under a duty to the other party, then the modern rule seems pretty natural. And so this is basically the sort of Hofeldian move, and it's probably no surprise that the shift happened around the same time that Hofeld's major contributions were being made. So, so that's the kind of key idea. Now, and you can see how this means that there's going to be consideration. First, the third-party promisor, not being the promisee of the prior contract, isn't the party to whom the previous duty was owed. They may have had certain rights to sue, but they weren't the party to whom the duty was owed in the sort of Hofeldian sense. So there's still something new that they can be given in that sense. So that first point focuses on the position of the third-party promisor and what he or she gains, but there's also the point of the promisee and what they give up. And through the second contract, the promisee is given up the possibility of being excused from performing the action by only the party in the original agreement. So that is, the promisee undergoes the detriment of no longer being bound to only one party who might release or excuse the obligation, but they're now bound to two separate parties in this relational sense. So these are the reasons why we've got this new modern rule. And I want to suggest the same rationales apply even where the third party is an intended beneficiary in the original contract. So first, while it's true that the intended beneficiary gains some legal rights if breach occurs, the beneficiary is still not the one to whom the original promise was owed. So, so as a result, the second promise to the intended third party does give the party some new benefit sufficient to count as consideration. What the party gets is a duty that's owed to him or her directly in this relational sense. Second, even though the promisee may have already been liable to the third party beneficiary, had he or she breached, the second agreement creates an additional liability. So sort of speaking metaphysically, whereas the promisee was previously under a single duty with two potential complainants, should breach occur, the promisee is now under two duties owed separately to two different parties. So that's a pretty abstract way of putting it. So let me try and be a little more concrete. Suppose that your friend owes me $1,000. Your friend's a masseuse and promises a free month of massages to you if you'll pay off his debt to me. And this amounts to a discounted rate, so you accept. Now, note that although this is a contract between you and your friend, I'm a third-party beneficiary, a third-party creditor beneficiary of this agreement. So your friend performs his side of the contract, gives you the month of massages. Now you have a duty to your friend to pay his debt, and I have the right that you do not immediately, and I have the right to bring suit on the basis of the agreement with your friend. But suppose, however, you don't have the cash to pay me, so you offer to promise me directly that you will pay me $1,000 if I'll discharge your friend's debt. And preferring your debt to that of your friend, I accept this agreement, right? So there's little doubt that this new agreement between us would be enforceable. That's what a novation is in contracts. But if this is an enforceable bilateral agreement, it must be supported by consideration on both sides. So there has to be something that we're both giving up and gaining. And the only way to sort of understand this is in terms of the relational conception that undergirded the first idea of the rule. So what this illustrates is that the same reasons that applied in the straightforward case of a contract with a third party also apply in the more complicated case. So that makes it seem like that side of the dilemma is also unappealing to take. Now, what I'm inclined to think is that the best option is if you go back to those four inconsistent propositions that we should get rid of, that we should reject option 3, that we should think that really third-party beneficiaries don't get claim rights. And that we have to interpret what third-party beneficiaries get as something other than a claim right. But I find this puzzling because then why not think the same thing about other contract rights as well? And we usually do think of contract rights as implying a duty, and it would be surprising if they aren't. So this is all just create a puzzle, and I'd be curious if anyone has thoughts on what the right answer is.
We can spend a couple of minutes with questions, comments, solutions.
A question. I just don't understand. Why does it turn on whether it's a claim right or some other kind of interest? is talking about whether or not we describe it as a claim rate or some other kind of interest. The issue is the directionality or the relationality of whatever this interest is, as opposed to whether it's a claim rate or something else.
Maybe. I mean, the claim rate is. The claim rate gets you to this conflict with the pre-existing duty rule in the sense that if I have a claim right, then you have a duty. The whole point is supposed to be, if you already had the duty, how can you be then promising and putting yourself under a duty if you were already under that duty? So that's the reason why the claim right bit seems important to me, but I'm open to the thought that it's just the relational, you can get the same puzzle going without it.
That third solution that you suggested seems to be taking it back to a time before third-party rights were recognized. And I mean, that is a traditional answer, that there is no claim right. And that the third party, and I'm not sure whether your connection between duty and claim right is quite correct, because I think the common law would tend to suggest where there is no suit, there is no right, and then also no duty. And whether you owe duty to me or duty to somebody else is a very different question, isn't it? And in your example of the massage, you haven't got or the debtor, whoever it was, whose debt was forgiven, hasn't got a claim right, but they could still set up a massage by way of defense. But that does not mean that they have an enforceable right that the recipient of the massages should get the massages. So, and I think that's a different side of the matter, whether you can set up something as a defense or whether you can place a suit on it.
So I'm not, I wasn't suggesting that we should by the third solution, I wasn't trying to suggest that we should get rid of, go back to the old times. I was more trying to suggest we need to, I'm just genuinely puzzled by this. So I don't, but yeah. But the thought was we need to think of it as some sort of different Hofeldian element. So it's as not a claim right, but as some sort of power or something. Now I'm not sure. Normally we would. I think maybe this is a mistake, but we normally would talk about contract rights as implying duties to perform, and we think of them in that kind of claim right correlated with a duty to do the thing way. And
but there is no duty, but there is no suit. You know, if I don't have the right to sue you, then you don't owe me a duty. You might owe somebody else a duty, but not me.
Well, that's complicated.
It's. I'm Ted-lab. Maybe I get it wrong.
No. It could be. We could think of rights in that way, where what we mean by you being under duty simply means that I'm in a position to sue you, and that's all we mean by duty. But there's a different sense of duty that's sort of the Hart-Hofeld notion, which includes this bit about being able to being the one to whom the duty is owed, who has the power to rescind it or waive it or other things. And that can come apart from being the one who's in a position to sue, as comes up in these third-party cases. So I guess I'm just not sure that I agree with that framing of what.
One more.
Nico, I think what you may be missing, what may help you answer the puzzle, is you don't factor in the reliance or lack of reliance of the third-party beneficiary on the contract. And I'll throw in law professorial style, instead of answering your question, throw in another wrinkle on your hypothetical. I'm a practitioner. This is an actual case that I'm writing an appellate brief on. And it shows you law students that sometimes they're contract law intersects with other areas of the law, in this case, family law. Mother and father have a marital settlement agreement in connection with a divorce, where they agree to contribute to the daughter's college tuition to the extent that they're able. daughter relies on that, supposedly, and files a claim as a third-party beneficiary to enforce the marital settlement agreement of the parent. I represent the mother. We claim that mother made a separate independent promise to the daughter to do nothing more than to guarantee her student loans. This should apply to all of you folks. Probably if you're in law school, you're up to your ears in debt. So I'm arguing that since the daughter relied upon the promise, the direct promise from her mother to guarantee her student loans, and she did not rely on the obligation of her mother pursuant to the marital settlement agreement, she's barred from enforcing the contract with the third-party beneficiary. You follow me? So I think that the element of reliance is important.
I mean, reliance is definitely important in that it can take these third-party cases where, from the situation where the original promisee can rescind the right, and it can sort of take it out of that right. So I agree that reliance can sort of change the circumstance in that way. I'm not sort of seeing how it sort of answers the puzzle, though, in that, I mean, maybe in the case where there is reliance, we can more easily say, yes, the third party now has a right because they've relied. But we can still imagine situations where there isn't this reliance and the puzzle is going to exist in those cases. But I'm glad to see that this is coming up in real, yeah, I've got someone in the room who actually has this puzzle. It's good to see.
Okay, we're going to move to Monika now. Go ahead.
Thank you. Good afternoon. First off, I just want to say how excited I am to be here. Obviously, I am a student and I'm here on my home court, so it would not be appropriate if I did not say thank you to a few individuals, well, specifically the law school community and all of my great friends that support me, and specifically to the St. Thomas Law Review under the direction of Trey Nazaro for affording me the opportunity to have my article published. And most importantly to someone that I don't think she's in this room right now, but to Professor Jennifer Martin, who without her, I probably wouldn't even be a law student. So. So now on to the substance of contract law. And my issue basically dealt with one thing that comes up a lot with contract litigation specifically, and it's ambiguity. But a lot of the issues that we deal with ambiguity to contracts are seen on the face of the contract, and specifically what does a term or phrase or clause mean for Gelman, for instance, and what are the essential terms? Are those written into the contract? Is there any ambiguity there? And so my issue addresses a different type of ambiguity that may not necessarily be seen on the face of the contract, and it can be a little bit of a sneaky issue that's undetected. And specifically today, I want to address whether or not a non-signatory to the contract can invoke the forum selection clause, or they can be bound to the forum selection clause. And so when we look at forum selection clauses specifically, we see that they are in their own category themselves, and they require certain analysis. We see that the Supreme Court, as well as other court holdings, forum selection clauses have required analysis to determine a few things. Was the forum selection clause effectively bargained for by the parties? Will the chosen forum be so seriously inconvenient that it may deprive a party of their day in court? Was the language unambiguous as that it was readily discernible to the contracting parties? And was there any fraud or undue influence or overweening bargaining power that may render the clause void? So these are a lot of the questions that are asked around forum selection clauses, and there's a lot of unanswered questions. And ultimately, the courts look at whether or not there's a fairness element that the courts look at, as well as the foreseeability. One of the major things about contract law, as we all know, is the ability for the contracting parties to know what they're bargaining for, know what rights they're giving up, and so forth. So, and today, the Supreme Court has given certain certain guidance with regard to forum selection clauses, but this guidance is incomplete. The Supreme Court has went ultimately from looking at forum selection clauses against the international flow and looking at them in the sense of what's called an ouster doctrine, and suggesting that they're unenforceable because they might deprive a court of their jurisdiction. And so these clauses have evolved over time, but there's still questions that have been unanswered. And I may be a little bit biased in this sense, but I feel like my paper kind of terms the group correctly in stating ghost parties. And these ghost parties are what I'm addressing right now is can an outsider come into your contract and determine, based on the forum selection clause, that that this contract should be negotiated or should be litigated in a certain jurisdiction, and vice versa. And as you stated actually a little bit earlier, contract law bleeds into all these different types of law. And here specifically, this is a bleed into consideration of procedural law and business law as well. And again, there's that issue of foreseeability that these forum selection clauses are trying to maintain. And there's a few examples as to, excuse me, I apologize, I'm a little bit nervous today, as you can tell. Ultimately, there are a few examples in case law that have shown us that every once in a while, a non-signatory can creep in and find their way into the contracts. And so we can look at a hypothetical, for instance, a product liability case to where someone is injured. So one party sues under a tort claim while another party sues maybe under the contract claim. And so right there, that's been an instance where the non-signatory has been merged into the contract to allow them to invoke the forum selection clause or be bound to the clause. And additionally, if you think about it, you have to take a step back and just, forget what you know about legal contract issues and so forth, and just think of yourself as an employee or a regular business owner and a consumer, and just know that these things can happen to you. And specifically, there's a case, the 2003 Alabama Supreme Court case of ex parte Procom Services, and basically this was an employee that sued his employer and two other individuals, and the court ultimately determined that the other individuals who were not signatories to the employment contract could invoke the forum selection clause and determine where the jurisdiction would be held. And this is the same thing with a business owner. On that end of the spectrum, this ambiguity, it makes you wonder what you're actually signing to. When you sign these contracts that with your business, and your business deals with another business, and that business deals with outside parties and so forth, how open are you to allowing these other parties to creep in and determine where you litigate? And this also can be looked at from the consumer's perspective as well, and my seminal case that I used through my research dealt with this through the consumer perspective. And that's a 2012 Seventh Circuit case of Adams versus Raintree Vacation Exchange, LLC. And in this case, the plaintiff was a purchaser of a timeshare in Mexico. And on the defense side, there were three different companies. There was DTR, which was a Mexican company, their affiliate Raintree, and Starwood. And the plaintiffs basically purchased the property through DTR, who they signed the contract with. And the contract had a forum selection clause that determined that Mexico would be their chosen forum. They paid on the contract, and DTR, Starwood, Raintree, and so forth, the businesses working on this timeshare, the timeshares were never built. So they basically took the money, they paid their debts, and they never built the timeshare. So the plaintiffs sued, and they alleged that Raintree had ultimately conspired with Starwood to defraud them, and pretending that this Mexican subsidiary, through this Mexican subsidiary DTR. And even though Raintree and Starwood were not parties to the contract that the plaintiff signed, they moved for dismissal based on the forum selection clause. And the Raintree court ultimately decided that even though Starwood and Raintree were not signatories to the party, they could actually invoke the forum selection clause. And this is interesting because they said they could do this in this instance, but this is not always the case. And so Judge Posner of the Seventh Circuit went even further, and he decided to create a test to determine when this actually applied. And so the general rule for these forum selection clauses is basically only those in privity of the contract may invoke or be bound to this clause. And the new question before the Raintree court was whether or not non-parties may be bound to invoke the clause or be bound to it as well. And basically, Judge Posner looked at the direct relation of the non-parties to the signatories of the contract, and determined that there should be a test to determine how closely related you have to be to a party to the contract in order to come in on that forum selection clause. And so Judge Posner suggested that there be an approach that looks at both mutuality and affiliation. And some courts before Raintree have actually followed this application of affiliation, specifically where a company is under common ownership with the company named in the contract, such as a parent company or a subsidiary. And so this right here creates that affiliate relationship between those parties to suggest that there may very well be non-party invocation here. But Raintree considered that this isn't always the case, and there has to be something that's a little bit more that would bind the parties. So ultimately, the court looked at to try to ensure that parties were not apt to shift their corporate entity in order to avoid a forum selection clause. So this was kind of what they were looking at. And again, there must be a reason to hold the non-signatory to the designated forum. And this is seen through an example such as a plaintiff's filing mistake. For instance, a great example is when a subsidiary company is a party to the contract containing the clause, and the other party to the contract sues the parent company rather than the subsidiary company. This would give a reason for the non-party to the contract to invoke that forum selection clause. And additionally, Judge Posner breaks it down a little bit more and suggests that if A is suing B and C, and both B and C are affiliates of each other, such as a parent company and so forth, these claims must be directly related to each other for the non-party to invoke the forum selection clause. And so basically the claims have to be related enough and arising out of this contract for them to allow this invocation. And the Seventh Circuit utilized this affiliation application specifically towards Raintree as the parent company of DTR. And then additionally, Raintree also looked at what's called a mutuality theory. And so under this theory, they looked at Starwood's involvement. And the plaintiff basically suggested that Starwood was defrauding, and along with Raintree, they were attempting to defraud the plaintiffs. And even though Starwood was not in the ownership chain, it did purchase a significant amount of money for the resort property and where the timeshares were supposed to be built. And this court ultimately determined that Starwood could in fact invoke or be bound to the forum selection clause on this theory of mutuality. But again, they stated that this is not always the case. And under mutuality, a contract made between the agent or the secret principals of a third party can be enforced by the third party against the secret principals if they so choose to. Posner said it made sense to allow Starwood to rely on the forum selection clause specifically because of the fraud allegations that were against them. So it was only fair to allow them to rely on this when they were allowing the plaintiffs to rely on it as well. And my article basically takes the test that is presented by Judge Posner in the Seventh Circuit with the affiliation and the mutuality that looks to the direct relation that the non-signatory has with the parties to the contract. And my analysis goes a little bit further and suggests that this is incomplete because there needs to be not just an analysis of the direct relation to the parties, but also an analysis of the direct relation to the contract as well. So in trying to simplify all this, I basically just suggested that we start out and we create these two specific groups, the directly related to the contract and directly related to the signatories. And then we look at it from there and we break it down even further. And with regard to the contract, we would want to look at specifically third-party beneficiaries and the rights that they would have to invoke this forum selection clause, as well as parties that have signed multiple contracts at the same time. This should also be a consideration if, for instance, one contract has the forum selection clause and another one doesn't. Were all these documents signed at the same time for the same purpose and so forth? And then we would go into the test that's presented by the Raintree court, and we would include these affiliation and mutuality principles at that point to determine what directly relates the non-party to the signing parties. And so that is my proposal for simplifying a little bit, even more so, forum selection clauses.
Thank you, Lee. We can have questions or comments. It occurred to me that it would be interesting to try to map this problem onto third-party, more traditional third-party beneficiary law. So, for example, is the consumer who signed the forum selection clause and gets it invoked against the consumer, has that person intended in some vague sense to confer forum selection rights on those non-parties? That would be the sort of the direct mapping onto third-party beneficiary. And I wonder whether the affiliation business that Judge Posner is talking about is a relative, at least, of that intended beneficiary idea. I mean, I could imagine one inferring from the original contract that the parties do intend, in some sense, again, to confer rights on those closely affiliated non-parties. But who else has comments? Sir.
You must think I'm an unstoppable moron, keeping asking questions, and I know nothing about American law, so I do apologize. But I'm very interested in the conflict of laws, and for me that would be a conflict case, looking at international jurisdiction. But what I didn't quite understand, I think the companies that you mentioned in the Raintree case, they set up the forum selection clause by way of defense, didn't they? They said, you can't sue us here. So they were, in a way, not bound by it, and you can say they are bound by it, but they just wanted to avail themselves of something there. Whereas in the other problem that you mentioned, from my perspective, from a European perspective, consumers cannot enter into forum selection clauses until after the lawsuit has arisen. So that would be the easy way out there. And the other question that I have, firstly, the role and invoking it by way of defense, I think is not quite the same as being bound by the clause. And the second aspect is what, I haven't read it, of course, but it sounds to me as if there are lifting of the veil of incorporation considerations behind it, where you said like companies closely connected and they have their ownership structure. So yes, they are being allowed to be sued in one place or the other because the other company who acts is a mere facade, a mere sham to allow them to get away with it.
Would you clarify one thing? When the consumer sued in Raintree, did they sue in the unchosen forum and
Yes.
had the chosen forum invoked against them?
Yes.
So it's almost like an estoppel,
Yeah.
in a sense. Okay. Well, you have any?
Will you say your last statement one more time, please, if you don't mind?
So the last point I think was about that I thought they were lifting the veil of incorporation aspects coming in, which would be like more we would say company law, business organizations, corporations, looking at whether the corporate form has been used just by another entity to hide behind it and be safe from liability. And this might be a case when the veil might be lifted, and this is why they say, look, they are all bound by the clause because they just acted through this little subsidiary, really just to hide the big entities behind it.
Absolutely, and that was actually a consideration by the Seventh Circuit whenever they were determining whether or not to apply this affiliation. They wanted to ensure that these companies that were trying to escape the forum selection clause just by setting up their companies like that could not do that. But on the alternative, there weren't any negative implications as well. So it's a work in progress, most certainly. But there's definitely that intertwining between contract law and business law for that matter.
Yes.
Very nice job, Monika.
Thank you.
I have a question. If you can't answer it, it's okay, because I know we talked about it for about 30 seconds in business associations. And it's slightly off the topic, but somewhat related. And that's regarding Delaware Court of Chancery's decisions to allow forum selection bylaws, where Delaware corporations can say in their bylaws, you were going to go ahead and you have to sue in Delaware, which is an effort to avoid a lot of duplicative multi-jurisdictional litigation about mergers, et cetera. Typically, courts have held that shareholders are parties to the contracts, which a bylaw is considered a contract, but often shareholders will not realize that by buying a share of stock, they're now agreeing to have their litigation held in Delaware. So I'm wondering if you have any thoughts about that. They're not third parties, but they're probably not in any way aware of this, and hundreds of companies are now starting to adopt these forum selection bylaws, and corporate attorneys are recommending that companies do it. Do you have any thoughts about that, given the fact that, again, the average shareholder does not realize that this is what they're buying into?
I think shareholders are a great group to consider the affiliation and mutuality principles, especially the affiliation. How are they affiliated with the company and so forth? I definitely am still progressively learning about the Delaware corporate bylaws and so forth with the forum selection clauses, but I think that that there could be an analysis for the affiliation principle. Yes, possibly.
The other question I had is the extent to which joinder policy and the efficiency of litigation and the rest of that is implicated in this. This seems another hybrid of that. Is that?
Yes, that's correct. There's just another crossover right there between contract law and procedural law, to where this is a hybrid. And the Raintree court actually does discuss this as well for the affiliation principle, saying that there needs to be a little bit more than just the affiliation, that there has to be a reason to keep the party in that jurisdiction. And so the joinder would be an issue that would be discussed under that. So.
Any others? Going once. Dustin, Zacks, you're on.
Okay, thanks. Hi, everyone. This is a work in progress that we've tentatively titled Not a Party. And it's about challenging mortgage and note transfers under contract law and property law. The starting point for this idea comes from some previous research I did into MERS. To give you the quick 30-second tour of MERS, it's Mortgage Electronic Registration Systems. It's listed on more than half of all the new mortgages actually in the country. What they do, and the purpose behind MERS, is they're essentially a placeholder in the public records. So when notes are sold dozens of times, for example, in a securitization process, MERS remains the mortgagee on the public records. What you would contrast this with is maybe 100 years ago, all of these assignments would have to be recorded at each step of the way. So it was expensive, it was demanded time, and it was a burden on folks who wanted to securitize loans. So MERS was created, and after publishing a couple articles on MERS and whether they can actually foreclose, one issue kept popping up, and that is the issue of MERS assignments themselves. So what happens is, no matter how many times the loan is sold, as I've said, the loans remain in the name of MERS. So when a bank or a servicing entity is ready to foreclose, they need to draft an assignment. They need to get something that says, okay, MERS is not the mortgagee anymore. So in case after case, regarding these MERS loans, the assignment issues would come up, and particularly from the homeowner side of the action as a defense. So some of these challenges that were discussed in the research were basically asking questions like, does MERS and their relationship with the original lender or successor lenders, how does that relationship work? Does it actually exist? And can they prove that they had that relationship on the date the assignment was drafted? MERS assignments also sometimes contain language saying that they're transferring notes. But that raises a question as well, because as I've said, MERS is mainly essentially just an electronic database is the easiest way to think about it. They are not a custodian or a traditional bank that would house physical notes. And MERS also raised questions in their assignments with their corporate appointment scheme. So contrary to the lofty titles that you might think of, a vice president of MERS can really be generated by paying, I think it's $15 on their website if you're a bank or a servicer, and they will print out a sheet basically appointing you as a vice president. So many of these assignments were challenged, and that's basically where we came to this point. So in a more general sense, not just with MERS loans, but in most loans, you know, one of the starting points here after the crash of the bubble has been that we all read the New York Times, loans were sold. So let's start from that point. And in court, the challenges to these assignments are raised as a way to say the foreclosing entity does not have standing, does not either own these loans or does not hold a note or any right to enforce that note as part of a foreclosure. So in many cases, the note is all that a bank or a servicing entity is going to have to bring to court. That's common in many jurisdictions. But as there have been documentation problems, as there have been problems locating original notes, especially in judicial foreclosure jurisdictions, what you have left in a lot of cases is just the assignment. In other words, that's the only piece of evidence that is going to show a judge how the loan got from the original lender to whoever the eventual foreclosing entity is. So there are other scholars who have researched into this area, what the law of property transfer is, a little bit more generally, not just speaking about assignments. And they point out that it's an intersection between mortgage and contract law. And our focus is just a little bit more pinpointed than that. It's specifically on the assignments themselves. So there are many articles out there that can tell you what various sources of law there are for property transfers more generally. What we're specifically looking at with this work in progress is those assignments of mortgages and what challenges they face, and whether they being homeowners or their advocates, whether they should be able to challenge those, seeing as they're not a party to that assignment. So one starting point, as we looked at those other scholars' works on the law of property transfers, is all the different sources, as I've mentioned. And it's a jumble in terms of what you're going to find across the nation for courts dissecting these transfers. There's Article 3 of the UCC when they're looking at promissory notes. There's state property law or state contract law, just common law that goes back hundreds of years. And there's also Article 9 that interplays in some of these cases. And then there's going to be many decisions you will find that say, as long as the note has effectively been transferred, that's the only issue. No assignment is going to be necessary or relevant. So as you look from that, that's the mortgage side of things. You consider the contract side of things, I suppose, and that's generally that contract rights are freely assignable. If you look more specifically at mortgages and notes, you'll see that most of the time the homeowners or the borrowers have specifically allowed the lender to sell that loan to whoever they want. It's specifically in that loan. So one comparison that we've made, it's something like an option to purchase in a contract law sense. And that analogy is basically if someone challenges your right to exercise your option, you know, what are they going to have to say to get at that? They're not an intended beneficiary, clearly. They're not a party to that contract. What are you going to have to say to a court to actually get them to uphold that challenge? So when we began the research into the case law into this area, the challenges that we found most commonly to assignments. One of them is the timing and date issues. So the core thrust of this argument is January 1st, 2014, a bank sues a homeowner. The bank will have to prove that on January 1st, 2014, they owned that loan, or that they were entitled to enforce the note. If an assignment is produced later in that case that's dated after January 1st, those assignments are being challenged on the grounds that the bank did not own it, they cannot prove standing, therefore they can't sue the homeowner, they're not entitled to foreclosure. Another issue that's commonly raised, going back to the MERS perspective, is an assignment on behalf of entities that are defunct. So you all are familiar with banks that have closed, certainly lenders that were writing these loans without much documentation. What you have in the case of MERS assignments, in some of the cases that we found, is MERS is assigning loans as a nominee for the original lender, because that's what the state of the title was left with. But to give you just one off the top of my head, is America's Wholesale Lender. That's out of business. It's been out of business for many years now. So homeowners have challenged whether MERS can actually show a nominee relationship today on behalf of America's Wholesale Lender when the company doesn't exist anymore. Going back to the date issue real quick, the date of assignments, one reason that has been challenged, and there's a lot of scholarship out there on this, is its relationship with pooling and servicing agreements. The pooling and servicing agreements, for the students basically that's the governing document of these mortgage trusts that everybody reads about. They govern when the transfers are supposed to happen, what documents were supposed to be produced, and those kinds of things. The arguments homeowners have been making that we've found is, again, if those assignments were done late and they contradicted the dates that were supposedly required in the pooling and servicing agreement, you follow that reasoning down the line. It was late, you can't foreclose because you can't prove that you owned it in accordance with the pooling and servicing agreement. Other challenges to the assignments, no proof of consideration, fraud, robo-signing. There was one empirical study, actually, of a scholar who was here at the conference, showing that a surprising percentage of assignments that you'll find actually weren't signed by anyone, that there were conflicting assignments, and that some assignments would have the same party on both sides. So those are other challenges that homeowners have brought here. So as we got into the research to really find out the state of the law and how courts are treating this across the country, not surprisingly, it's a new issue, so it's a jumble. But in most of the cases that we're finding, challenges to assignments by a homeowner or some other third party are really only going to be allowed or entertained by courts if they would render the assignment void rather than voidable. So we'll get into that distinction a little bit and what our thoughts are on that and what the doctrine maybe should be. But the distinction there is, I'll give you one example. There was a Michigan court that they actually did examine the challenges that the homeowner brought. And they said the reason they did that is if the challenge was going to be found valid, if they assumed those allegations were true, whether it was robo-signing or whatever, that would have severed the chain of title. In other words, it would have been a null and void. If they could have proved that the assignor never had the right to assign that, it would have been void, and that's why they looked at it. Now, ultimately, they ruled against the homeowner in that case, but that's why they kind of peeked behind the curtain, so to speak. Now, that's, again, as I said, that's a consistent distinction we found really across the country when homeowners are bringing these challenges. But in terms of what the voidable distinction is, I've only given you one example, really, and that is you can only assign what you own. But there are other distinctions between void and voidable, and we're still getting into a lot of those cases, and there's certainly no uniformity on what courts are saying makes that difference. So, and I have no idea how I'm doing on time here, but the final thoughts here and where this leads us to is, okay, it's a jumble. These are all new issues because, after the bubble burst, these are very new cases, new issues that are being brought to the forefront. Certainly nobody had ever heard of MERS 10 years ago. It's a young company. So we question what the rule should be. And if you fall on the side, as I do, that says in general, we should let homeowners question these assignments. We should let homeowners, for example, take discovery on these assignments or question witnesses regarding these assignments. Then these are our thoughts in terms of what supports that or what the positive outcomes of that might be. One is that it's support for judicial and courts' integrity. And that might sound lofty and idealistic, but one of my previous articles was on foreclosure law firms, high-volume foreclosure law firms. And there was a quote in there that said this was the worst crisis in lawyering really in like 100 years or in the history of the American bar. So that's a real issue. This robo-litigation and these robo-signed assignments, they actually are out there. That's not a made-up issue. So if companies know that they are going to be put to the test on these, the theory is you will induce them into being more careful in the future when they create these assignments. Double liability is also a concern for homeowners. So the whole idea with challenging standing has been prove that you, foreclosing entity, bank, or servicer, prove that you own this so that I don't get sued next week by a second company claiming that they are the true owner of this loan. So that's another reason to essentially put banks to the proof and make them prove their claims through challenging the effectiveness of the assignments. It also raises some procedural fairness concerns, and what I mean by that is we have looked at a small keyhole of these mortgage cases where the assignment is the important issue. So in those cases, if the assignment really is the only piece of evidence, and courts across the country are letting banks put those into evidence during a trial or a summary judgment, then fairness would seem to suggest that homeowners and their advocates be able to ask questions about those. And yet, by and large, as you've seen from some of the case law, they are being prevented from doing so on the basis that they're not a party to that contract. Another few externalities that we spell out as kind of the positive effects would be deterring the corporate side of the bad documentation practices. The main thrust of this would be in the securitization aspect. There have been many popular press articles on how securitization and the documentation procedures therein were not strictly followed. There were all kinds of problems regarding lost notes, certifications that were never produced, and those kinds of things. Again, the idea, if you are pro letting homeowners challenge these assignments, is the corporations and the secondary market will become aware of that, and they'll be more careful in the future. The other couple, I think, positive aspects of allowing these challenges is going to be title issues and promoting the integrity of the public records. And so this has also been explored a lot in the MERS context. And Chris Peterson probably is the foremost scholar on MERS at this point. But what he generally argues is that MERS as this placeholder across the nation, as this ubiquitous mortgagee, whether or not they actually ever send a letter to a homeowner, ever collect on a debt or anything like that, that does all of us a disservice because public records are supposed to mean something. We're supposed to be transparent. We're supposed to be able to go down to the courthouse and look at the records and see who actually owns the liens on a certain piece of property. So it's the same idea here. These documentation problems with assignments, that doesn't just affect the parties to the contract, doesn't just affect the S&R and the S&E, that affects the public, that affects the title insurer, that affects the next buyer of that property. So again, it's another argument in favor of allowing those challenges. Now, real quickly, just to get to the counter arguments, of what I suspect would be the most common arguments against allowing homeowner challenges. And real quickly, it's a argument that it's not going to fix the underlying causes of the housing bubble or the housing crisis. And I think there's something to that. This is not going to be, this is not going to fix the foreclosure crisis. But I do think, again, the next time around, if banks know that they're going to be held to the proof, if they know that judges are going to allow challenges and allow homeowners to ask questions about these assignments, I think they'll be more careful. I don't know if it would prevent another bubble, but that's one counter. The other argument is it's going to cause delay in the foreclosure process. And there certainly have been a lot of popular press articles on that, which is the more arguments like mine that I've made today that you allow in court, that's just going to delay those cases. It's going to delay the resolution of the market. What we should be doing is speeding up the resolution of the foreclosure crisis. And by speeding up, I mean getting the homeowners out of there, letting the process resolve, whether it's a dismissal and they get a free house or whether it's a foreclosure auction. Let's speed up the process, let the market bottom out so we can get those properties back on the market. And then the final issue is it's really a distraction. It's just a procedural nicety, which is disguising the fact that double liability is remote. So when I raise that as a specter for the homeowners that they're worried about getting sued twice on the same loan, in actuality, we were not able to find a lot of these cases where it happens. And certainly there have not been a ton of them referenced in the popular press. So again, it's a work in process. We might find some additional cases of that. But I think that counter-argument, there may be something to that. If that's where you're looking to get permission to challenge an assignment, that's probably not your best argument. So I sum up with this thought, which is one of the scholars who writes in this area noted the irony, which was maybe 50 years ago or 100 years ago, it used to be banks and foreclosing entities. They were the ones going to court and talking about formalism. It's the letter of the law. It's the letter of the mortgage and the note. And the assignment says what it says. We've got to hold everyone to that. And the irony now is that with the documentation problems, we've kind of flipped that on its head. And it's homeowners who are asking judges to hold banks to all these requirements of property transfers. So, thanks.
Comments and questions? Sir?
I know you said it's work in progress, but as far as the consequences for the homeowner and for the, I guess, you would say the alleged note holder, what would you foresee would be the consequences if they were to find the assignment was void, not void?
If they found it void, my suspicion is they may be able to go back and simply create a new valid document. I don't think there's anything preventing them from doing that. And oftentimes, what you'll see in a lot of these cases is it's a successor entity anyway. So America's Wholesale Lender is a good example because I think they morphed into 5 different incarnations of Countrywide. So the assignment in your case might not actually say America's Wholesale Lender. You might have formerly known as this, formerly known as this, formerly known as this, assigning to the eventual foreclosing entity. So I don't know that it's going to prevent that many foreclosures. But the issue is, making sure that that's correct. So these issues, and the reason I talked about the title issues is because that has been a real fear. When all the robo-signing stuff hit the news, especially down here in Florida, one of the big concerns was that looming specter in the background was going to make title insurers skeptical of insuring any policies down here. So I don't know that, by and large, you're going to get homeowners winning free houses. I don't foresee that. I do foresee banks will be a little bit more careful about their documentation.
I wanted to know if, to what extent you think that this is a problem with the protocols that are actually in place for the MERS system, because, like you said, we didn't used to think about this as MERS. MERS is more new lingo. And so when I think about protocol, I think about any number of other both private and public systems that we allow everything from the regular, these type of transfers, regular real estate transfers, or like registries that we have for UCC filings, or for stock. We're able to move stock at such large volumes because we have depository trust and others out there that facilitate those transactions. And mortgages would be akin, particularly with the securitization, if we're going to be able to bundle and trade these. The volume aspect is necessary, but then maybe this is just a simple issue of the protocols that are used at the outset and they were flawed in the beginning.
I like that point a lot. There are a lot of pieces out there now that talk about how can we make MERS better. It's and you're going to find every side of that coin. So there are some, I think, Professor Peterson, Chris Peterson would probably be on this side of things. He would say, get rid of it, scrap it. It was false. What they're saying in mortgages is false. They can't be the mortgagee and the nominee at the same time. all the way to the other end of the spectrum, which was one of my earlier suggestions was essentially just nationalize it, make it regulated. You know, there might be problems with that, and I listed some of them out. It's not going to be a quick fix, but if transparency really is your concern, well, make them a national registry and let anybody in here go up and look and see who MERS is the mortgagee on behalf of, so that they know who owns their loans. So I don't disagree at all.
Over Rick Scott's dead body.
First of all, I'm so glad I came to this presentation instead of listening to a bunch of stodgy old law professors. Dustin, very timely topic. You mentioned securitization, you mentioned Countrywide. Another war story that I have, I defended a commercial foreclosure arising out of the Washington Mutual collapse. You recall that? And
Sure.
my recollection is that there was literally a midnight deal where I believe J.P. Morgan Chase acquired all of the loans of Washington Mutual, if not bigger, if not as big, if not bigger than Countrywide. And I challenged the foreclosure because the plaintiff, actually then it was assigned to Deutsche Bank. Deutsche Bank never alleged that my client's particular mortgage was part of the asset purchase. Through discovery, I asked them, show me that my client's mortgage is listed in the asset purchase agreement. They referred me to a website in their discovery response. They referred me to an asset purchase agreement that had a schedule of the loans that supposedly were acquired. There was no schedule. So this was one of the times for you students, you have an argument that thinks going to make you famous and rich, but the judge denied my motion to dismiss the case, basically saying, if I allow this, half the mortgages in this county, you know, I'd have to invalidate. So this is what's happening out in the real world.
Yeah, I appreciate that point. And one of the things we note when we're looking at all these cases is the judicial skepticism. So what you'll find in a lot of the case law in this particular area is even when judges kind of peek behind the curtain and take a look at the validity of the assignments, or they do the what if game. Well, what if these claims were correct? Many times you'll still see the courts preface that with something like, well, the homeowners never disputed they were in default. So it's this idea that even if this claim were true, someone has to foreclose. So that's an issue, you know, obviously I take issue with because I'm on the pro side of this. I think that's pretty clear. But no, I appreciate that point. And the related point to that is, again, we focus mainly on assignments, but this question is also relevant to the pooling and servicing agreement arguments. The only difference I see really is when I'm contesting an assignment or I look at these cases, the typical argument is you're not a party to that agreement. I would say the more common thing in briefs or in cases with a pooling and servicing argument, with an argument based solely upon a pooling and servicing agreement, would be that you're not an intended third-party beneficiary. So it's a very slight distinction, but that's a difference. So again, we focus mainly on the assignments, but I appreciate the point.
Technically, as I understand it, the bank plaintiff needs to show, what would technically be required would be the bank would need to show the series of assignments that got it the loan or the note or the mortgage. And it would seem to me that it would be pretty easy, given the numbers of those involved, the numbers of those interim assignments, for many homeowners to simply put the bank to their proof and win under burden of proof, normal civil procedure. And as you said, and we all know, the game doesn't work that way when the consumer is on the receiving end of this. And I'm trying to figure out whether there are other areas of litigation where the burden of proof is so relaxed or presumptions flip the other way, other than where consumers are the defendants. And I don't know of any, but maybe I'm just cynical.
Well, it makes me think of the debt collection industry. And so some of my previous research was on large volume foreclosure firms. So one professor who responded to the article, one of his comments was, well, what about other large volume law firms? It's the same idea. Mm-hmm. So debt collection firms that just send out thousands and thousands of letters, that's not that much different than the malfeasance that I kind of found with some of this earlier research. So it does exist, and one of the arguments we're kind of toying with is if you allow these challenges to the assignments, it may be a signaling effect to other areas of law. So in other words, if you allow homeowners to start putting them to the proof in foreclosures, perhaps that spills over to debt collection attorneys. Perhaps they're more worried about an active judiciary.
Other questions? Well, let's join me in giving our panel a round of applause.